How do I successfully protest an IRS audit decision? Well, this is, again, if you received a 30-day letter and you're writing a protest to an audit, this is what needs to be included in that protest. A statement that the taxpayer desires to appeal the findings of the IRS to the appeals office. It must include the taxpayer's name, mailing address, and daytime phone number. You must include with your protest letter a copy of some correspondence from the IRS that speaks to the action that you're appealing. If it's an audit, the IRS audit report. If it's a collection action, the proposed collection alternative that they are bringing against you. You must include that correspondence with your protest. You must specifically list out what it is about that correspondence that you disagree with and wish to contest. You must specifically address the tax periods at issue. You must provide a statement of facts, which are the facts that you're relying on that should get you a different legal result than the IRS is proposing. You must include a statement of the law that you're relying on, a list of the primary authorities that gives you the legal grounds for the position you're taking. The taxpayer is required to swear under penalties of perjury that the facts as you're stating in that correspondence are true, accurate, and complete. Matter of fact, the following jurat must be used. Under penalties of perjury, I declare that I have examined the statement of facts stated in this protest and in any accompanying documents, and to the best of my knowledge and belief, they are true, correct, and complete. What you need to understand is that your protest letter needs to counter the revenue agent's report and show that the IRS's litigation of the issues in your case are either inappropriate or hazardous to the IRS. The detailed factual statement and legal arguments made in your protest should indicate whether the revenue agent has failed to set out facts accurately, or rather has failed to consider necessary facts to reach a proper legal conclusion. Where necessary, the factual statements in your protest should be supported with documentation, affidavits, and statements of potential witnesses. From my perspective as a tax attorney, I can tell you that the most effective protest letters demonstrate immediately to the appeals officer that reads them that my firm, myself, has a firm grasp on the facts, has a firm grasp on the law at issue, and most importantly, that we're ready to proceed to trial if necessary to defend our position. One advantage to the taxpayer in writing a protest letter is that the attachments to the protest letter do not have to conform to the rules of evidence at this stage of the case. I can tell you this, unnecessary information contained in a protest letter may backfire in that it may give rise to new issues that come up in the appeal that were never discussed in the original audit. Your representative, therefore, should not make a haphazard submission of documents along with your protest, but rather should carefully review each document before submitting it to avoid the possibility that new issues surface in the appeals process. In some circumstances, your representative may feel that you're better off providing excerpts of documents rather than the entire document. Take a board of directors meetings minutes, for example. If a protest fails to set forth the taxpayer's position, lacks substantive detail, or is otherwise seriously deficient, appeals may return the case to the original office where the examination took place for a redetermination of the disputed items raised in your protest, with or without a recommendation to proceed to assessment, in an attempt to make the amounts owed on the original assessment permanent.